Hi everyone, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So I have a great topic for you today, and it's has an employer ever... Okay, so I just lost connection on on Instagram, so I'm going to reconnect so that I can talk about that topic. All right, so just hang tight while I set up here. Okay, so I think we're gonna be back online. And Wahuri, I think I'm hoping you're saying you can hear me. Uh, All right, so I think I'm back on track. Thanks for your patience. Okay, so Wahuri, I'm back on track. Thanks for your patience. I'm both on Instagram and I'm on YouTube. So I wanted to make sure that I have connection with the both of you. I was interrupted a while ago, and so I lost connection on Instagram, but now I'm back. So thanks for your patience. Thanks for coming on again. Now let's get back to the topic at hand. And the topic today is going to be has another lawyer ever told you that you had to stick it out with a spouse, you had to make it work. There was no other option. You have to make it work in order for you to finish your green card process. You may have gone to the lawyer that you may share with your spouse to tell them that they are mistreating you, or refusing to apply for you, and you're trying to get advice from that lawyer that's representing both you and your spouse. You're trying to get advice from them as to how you can go about doing that, whether you have options going forward. And I can tell you this based on what others have told me and based on my experience. Many lawyers, and sometimes those non-lawyers too, like the notarios or the legal consultants, will tell you there's nothing that you can do. You don't have any options. You need to make it work. That is completely wrong, because if your spouse is mistreating you, if they are abusive towards you, you have options. You can switch from the marriage-based process where you're applying through your spouse to a process where you're applying for yourself. And this process is there to protect you, because no one is supposed to be mistreated emotionally, physically. You're not supposed to be threatened. You're not supposed to be blackmailed based on your immigration status. So if you're going through a situation like this, where you're having problems with your spouse, or you don't have a lot of trust that your spouse is going to treat you well during the process, just know that there are other options to protect you, to help you to finish your process on your own. without involving that spouse. Now, what kind of mistreatments can qualify you for this option where you can apply on your own? Now it's going to be based on mistreatment, and mistreatment could be emotional mistreatment or extreme cruelty, abuse. It could be physical, but it doesn't require that there be physical, because remember, emotional and physical abuse, they result in trauma. The physical may leave internal and external scars. The emotional does also leave those scars. It can even manifest itself physically when you're stressed out. You may lose weight, you may, gain weight, you may age because you're so stressed out by the emotional mistreatment and extreme cruelty. Also, keep in mind that in order to qualify for this, you don't necessarily have to even show that you've been abused, but you do have to show extreme cruelty. Extreme cruelty does include behaviors that maybe are manipulative, controlling. Maybe they've taken away your passport, or they're refusing to apply for you because they don't want you to get your status. Maybe they're vindictive, they're jealous, they intentionally do things to hurt you. Those count as well. So that's one of the things I help my clients with when they're going through this immigration process, is I help them to get through it successfully on their own. This can apply as an option even if you've already filed the papers, but you know already that you really cannot stick it out any longer with this spouse because they are abusive, or they're mistreating you, or they're extremely cruel towards you. If you have a U.S. citizen or legal permanent resident spouse who is doing this to you, you could apply for this option. Now, with this option, you're able to get a work permit, you're able to get a travel document, and you have a path to permanent residence. You get to stay here in the United States, so you don't have to leave. Even if you're out of status, you don't have to leave. And even if you yourself, you've had arrest in the past, or you've had immigration violations, if they make you inadmissible, we can sort that out by requesting that they forgive those violations so that you can stay here to apply for your green card. So there are solutions that we can help you to seek without involving that U.S. citizen or legal permanent resident spouse. Now, one thing is that it not only covers the spousal relationship, but it also covers the parent-child relationship. If you are the parent of a U.S. citizen who is 21 and up, and as children they gave you a hard time, they mistreated you as children, maybe they had substance abuse that made them abuse you emotionally, even physically. Maybe they had emotional issues. These can also qualify you as the parent of a U.S. citizen to apply for your own process. Now, if you're the child of a U.S. citizen or legal permanent resident, if you're under 21, this is also an option for you if they mistreated you. So if they disciplined you physically, excessively, if they called you names, if they yelled at you constantly, if they put you down as parents, then this could qualify you for your own status without involving these relatives. So this is completely confidential, and they will not require that the spouse, the parent, or the citizen's son or daughter sign off on anything, sign off on any documents or anything like that, corroborating your story. That is why it's important, though, to get legal representation, because at this point, that's going to matter. How you present your case, what you present, the type of evidence you present is going to be very important. The evidence, you don't need police reports, you don't need pictures of a black eye or physical injuries, you don't need medical records. But there are, and the types of evidence we use is really going to come down to what can show, what can support the claim here, what can support what you've been through, to show that you've been through this. And that's where I brainstorm with my clients. Any credible evidence counts. That means any believable evidence. And so I work with my clients, brainstorm with them to figure out what they have. Because yes, when you're dealing with emotional abuse, it's not necessarily documented. And so we look at what happened in the relationship and what can you present. Now, I also help my clients to put a solid declaration together, and when done correctly, consistently, and detailed, then they can determine, the immigration service determines whether it is credible enough to be accepted as evidence. So it is flexible in regards to evidence, but you still do have to make sure that you understand that you have representation to help you through the process. The process takes about 2 years, 2.5 years, but the good thing is you get to get your work permit for part of the time that you're on the way to the green card. You get to get your work permit, your travel document, your social security number, and your children who are under 21 and unmarried. Once you've been approved for Vawa, they then can move forward with the process with you. And if your stepchild has gone through this type of mistreatment by the U.S. citizen spouse, then they could qualify independently as well. So your child could have options as well if they're here in the United States with you. But even if they were not victimized in any way by the spouse, or your parent, then you could still apply for them on your application, and the application would be processed for them to get their status here and their green card once you get approved for the Vawa. So there are different stages. So there's Vawa, and then once you're approved for the Vawa, it moves straight on to the green card process. So I think when you're in a situation where you have to be, you're with a spouse and they are mistreating you, if another attorney is telling you that you have to stick it out and fix the situation in order to get your papers, that's not true. You don't deserve that, and you should definitely make sure that you cover yourself, that you take control of your situation through this Vawa process. So that's going to be it for me. But remember that the information I'm giving you is not legal advice. It's general information. So if you want personalized legal advice and representation, that's where I'm going to leave it to you to schedule that consultation so we can talk in detail. Thanks so much, Harper Stewart. It's nice to see you here. I appreciate the encouragement. Go ahead, drop your questions in the comments, because that's why I'm here. I'm here to answer your immigration questions at the same time. So put those questions in the comments. Huri, thank you for the encouragement on YouTube. You can also put your questions in the comments there. Your questions can be anything that's immigration related. So go ahead and put those questions in the comments. All right, so in the meantime, while I'm waiting for your questions, I want to tell you how to schedule the consultation. So you can schedule your own consultation by going to the website. It's going to give you the contact page where you can go through the form and schedule your own appointment. You don't have to call, just go all the way through so you can confirm the appointment. If you need assistance, you can call the office. You can call the office at 561-405-4889. That number is on the website. So go to the website and you'll see the number at the top of the page. It's also on the contact us page. There's also a web form that you can complete if you need us to contact you. We usually contact you within 24 hours of you completing the form. And then there's also the online chat. So if the scheduling coordinator is available, they will be available on chat to speak with you and answer your questions and then help you to schedule that consultation. The consultation is going to be very important to sift through your details and determine whether you qualify. But what I can tell you is that my clients, they find peace, and they get to the point, usually when they start with me, they come to me, they're sometimes hurt, they're uncertain of their future, they're afraid because they're facing threats, either threats not to file the papers, threats to stop the process, threats to call ICE or get them deported. And so they're really in an uncertain state in their life. But a couple months in, when they start to see the results, they get that peace of mind and they fully understand why it was the best option for them. So go ahead, schedule that consultation so we could talk about whether this is going to be a good option for you. Now I see questions coming in, so I'm going to go ahead and answer. What if my adopted parents, which are US citizens, tried to send me back to the island because she was trying to be cruel to me? Do you qualify for Vawa? So Elora, yes. No, if it depends. You say adopted parents, but we would have to sift through the legal ramifications of that word adopted. But if they legally adopted you, and they are now threatening to send you back, that counts for VAWA. If adoptive parents qualify for this, adopted children qualify for this. So absolutely, what you can do is call, schedule a consultation, and let's talk. You have, when you're applying for this from a child's perspective, or the child of a citizen, you have up until you're 21, but there are exceptions if you're under 25. So the clock is ticking. If you're under 25, we need to talk to figure out if you meet that exception to apply and get your application in ASAP. So go ahead, call. You can go to the About Us tab on the YouTube and click on the link. But yes, adopted children qualify for VAWA. Does male 14-year-old derive automatic citizenship from a parent that is naturalized? The child has a non-immigrant visa. So the automatic, usually they have to be, now it's going to depend, right? Sometimes the facts can be complicated and it's going to depend. The 14-year-old, at what point did the parent become a citizen? If they're 14 at the time that the parent became a citizen, they would also have to be admitted as a permanent resident in order to be able to get citizenship. But if you were born to a US citizen parent, then you may very well have derived citizenship from birth. So it's going to depend on the facts here. So it's very important that you get a consultation, because whether you have automatically derived citizenship from your parent is going to be very fact intensive. For example, there are certain requirements that you have to show, not just permanent residence, but you also have to show who has custody of the child. When was the parent a citizen? How old was the child when the parent became a citizen? Where is the child? How long has the child spent in the United States? So all of that is going to count here. And sometimes it even matters how long the parent has been a citizen as well. Also, what documents need to be submitted for the child if he does not derive automatic citizenship? So that is going to be complex. So you need to schedule a consultation, because the first thing is have they derived citizenship? Because I see here they have a non-immigrant visa. So there are a lot of facts that we have to sift through here to see if that can be the case. So I've been waiting for prosecutorial discretion for over 4 months. What should I do? It's in Chicago ICE office. So you're not alone. It is quite a process. And believe it or not, 4 months is not necessarily a long time compared to others. So it depends. If you have an attorney, contact your attorney and state your concerns. If you have direct contact with the ICE or get an attorney, it's always best to make sure you have legal advice and representation. But also, I wouldn't be able to advise you directly, but you may have to, if you're representing yourself or you're advocating for yourself, you may have to get in touch with them directly to make sure that it hasn't been lost in the shuffle. What is the cost for the consultation? So it's $150 for up to an hour. And my consultations are not just a quick, cursory, glaze over your issues. I really want to make sure that I have sifted through all your facts to determine that you understand what your options are, not just maybe what you may be thinking about. Sometimes my clients come to me for one issue and they find out they qualify for another thing. So, it is worth your time to schedule it, and it helps you to avoid devastating mistakes. All right, so let's answer some questions here on Instagram. When USCIS say they are actively reviewing your case, what does that mean? So it just means, the way I picture it is that it's somewhere on a pile on someone's desk. It's somewhere, may be at the bottom of that pile, but it doesn't mean that an officer is now, sifting through every page. I have seen that actively reviewing your case for a year. So it doesn't necessarily, indicate that you're going to get a decision tomorrow. It can sit there for months or even a year, even over a year. So just keep tabs on your status, but it doesn't mean much. It just means that it's past the mailroom and it's going somewhere. It's going on its way or it's on somebody's desk. Can you really use a travel document from Vawa? Yes, you can, but whether it's advisable for you to travel. So for example, it's really going to depend on your particular circumstances. For my clients, I do get their travel documents for them, but I tell them, do not travel without telling me in advance when you're going to travel. Just to make sure we keep tabs, to make sure at the time that they leave, it is advisable that they can leave and that they don't face any risk of being denied entry. But yes, that travel document is legit. Will my 17-year-old son need a permission letter from his father to immigrate? My husband and I, what if he refuses to write the letter? So that is a very specific question. And it's going to depend on what's going on. I mean, if he's in the custody of the father and he doesn't want to let your child go, then that's definitely going to be an issue. So it's not something I could advise on unless, my client was in that situation. If you enter the US illegally through Mexico border, can you get the green card? It's possible. So for example, Vawa, the process that I just talked about, where you're applying based on mistreatment by a citizen or permanent resident spouse, a parent, or a citizen son or daughter, this applies, this form of relief, even if you cross the border without permission. That allows you to stay in the US and finish out your process here without the need to leave. There are other forms of relief where you can apply for a waiver, and it allows you to finish out the green card process, but you still do have to attend the interview at the embassy. So there are different options, but whether that option is going to work for you is going to depend on your particular circumstances. So that's where it's important to get the consultation. One, word of advice, and I think warning here, is that don't wait until you've done something, you filed some papers before you get legal advice. It's never too late to get legal advice or representation, but it sure helps when you do it before you get legal advice and representation before you do anything. Because I have had some consultations where people, they file all sorts of things, not knowing whether it's going to work. They're kind of just throwing stuff on the wall, hoping it sticks. And then when things get chaotic or something bad happens in their immigration process, that's when they're coming to me. And sometimes it's really expensive to fix, or it can't be fixed at that point. So very important that you understand your options before you do anything, and then get started on those options that an attorney provides for you. Hi there. So you have a question. My son, I-130 is approved, and VC sent a greeting email, but I still don't understand what's next, the next thing I should do. So it's going to depend if an immigrant visa number is available. Then they're going to start processing right away. But if you have to wait for an immigrant visa number to become available, it's going to sit there until they're ready to process your case. And that's going to be based on the priority date. There's a whole chart that you have to refer to understand how much time it's going to take. If I'm currently on a valid F1 student visa and waiting is waiting an interview date for green card application, can I travel outside of the country? You can't just get up and go while you're going through adjustment of status. You do have to make sure that you qualify for, you get a travel document during your adjustment of status. So you have to make sure you get that travel document, because if you leave the country while an adjustment of status is pending without getting the travel document, your application will be denied. Even if they let you back in and you go to the interview, they're going to tell you when you left the country, you abandoned your adjustment of status, and they would deny it. And you may have to refile, and it can cause a lot of problems. So no, you cannot, and it could trigger inadmissibilities too. So you have to be very careful. Can you get a mortgage on the T status? So non-citizens and non-permanent residents can get homes here and can get permanent residents. Get a mortgage. So yes, it's possible, but whether you qualify is going to depend on the financial institution, the bank, the seller, and you as the buyer, but that could be a possibility. These are all great questions. Okay, I see another one here on YouTube. So good evening. So I asked you yesterday, I submit my documents 4 months ago. Please, how long are they going to prove for me? So I wouldn't be able to tell you, because I don't know what application you've submitted. I don't know what documents you've submitted, and I'm not the attorney representing you. So if you really want to get down to specifics, you should schedule a consultation. But when you submit documents, I really, based on your question, I don't know where you are. I don't know what you've applied for. So just if you want to follow up, tell me what you've applied for, what documents did you submit, and what stage of the process are you in? Have you done your biometrics? And then I can maybe give you an approximate timeline based on that. All right. Do you take cases that are at the NVC? Yes, I do. I take those cases. Now, while most of my clients I represent from the beginning of the process to the end, that's always the best, because then I know what I did, and I know, I understand the process. Sometimes taking it at the NVC can present challenges for me, because if mistakes have been made, it's going to show up at that National Visa Center stage, and it may cause delays. And so I can definitely speak with you in a consultation, and then talk about what's going on at the NVC, At that point, we can talk about representation, but I can definitely start by advising you and then representing you through that stage. Now, and this is a good time to talk to you about the National Visa Center, because this can be a very frustrating stage of the process. If you're doing it for the first time, you may find that you're back and forth with them at least once every 3 months, and that is making your case go longer and longer and longer. You really have to be very meticulous at this stage because they are very specific about the documents they want, and if you present the documents incorrectly, they will tell you 3 months later, and then when you resubmit, it may take you a while to resubmit, they will tell you 3 months later whether they've accepted it, and this can go on and on. And so I have had one client that after 2 years of going through this with the NVC, they finally came to me and asked me to take over their case at the National Visa Center because many mistakes were being made and they kept on rejecting their case. So that case was delayed by 2 years. At what point during the adjustment of status process do you submit evidence? Is it with your package or at the interview? Great question, Serenity. And this is also one of those cases where I see a big mistake. People rush, and they have this idea that the adjustment of status papers, it's just filling out forms. We'll fill out the forms and worry about the rest later. It really is a work of art. It's not just filling out papers, it's understanding the legal requirements and the required documents and the evidence. And so what I find is people they fill out the application very nicely, and then they send it in and they get RFEs. They may get denied before they get to the interview. Then they go to the interview and they find that the officer is very, very skeptical about your qualifications because you didn't submit any evidence that would give them, while they're reviewing your file, they would have a good idea that you have a valid marriage, or, if this is employment based, that you're qualified for it. So you shouldn't be, definitely when I represent my clients, we work hard, we get everything done on the front end. It's so important to submit solid evidence with your adjustment of status. So this is not just paperwork, my friends. This is this is very, very serious stuff. And so you definitely shouldn't be saying, I'm going to submit this and then I'm going to bring, the evidence to the interview, because by that point it may be too late. The officer may have made their decisions already. And then the thing about it is that when you prepare the adjustment of status application and then you don't submit all the paperwork because you think you can just catch up with all of that later, it ends up, you go to the interview and you don't even understand what to take. And so you go in with evidence that they really don't want to see. And so that can mess you up even further. I have seen denials happen because of this. I've seen accusations of fraud because of this. I've seen cases being delayed for over a year because of this. So evidence at the front end is always advisable. What if you don't have a joint bank account with your spouse? Can you still go ahead and start paperwork? So boss baby Donnie, what I would say here is that marriages aren't a one size fit all, right? All of my clients, they have different types of marriages, different types of arrangements. So what I find is some people, they try to meet this standard view of marriage. And what they do is they didn't have a joint bank account, but right before they file the adjustment of status, they run and go get a joint bank account. And the joint bank account has like $20 in there. They submit that, and that creates a red flag for the immigration officer, because by looking at that, they know that you opened that account with that person, with your spouse, just to file the papers. So, being a married couple, there must be evidence, real, genuine evidence that you have together to show that you are a married couple and you're looking forward to your lives together. That's where I come in when I represent my clients. I study my clients as individuals and as a married couple, and then based on that, I often say putting a marriage-based application together, it's like a story, it's like an art of storytelling, right? You're telling the story of this couple and their marriage, how they met, how where they want to go with their lives in the United States. And so we do that with the evidence. So it's not about, the standard bank account, joint taxes, because some couples, they choose not to file joint tax returns because it's not advisable in regards to taxes. Maybe one of the spouses owes a lot of taxes, while if the other spouse would pay less taxes, and so they choose to file, maybe married filing jointly, and that's allowed, right? So it may not work for that one couple, and so in a case like that, I just go through the everything with my clients, and what kind of marriage do they have, how do they share in the responsibilities, and then I use the best evidence to tell their story. So that is what we do here. So at what point during the adjustment of status process do you submit evidence? Is it with your package or at the interview? I answered that extensively. Okay, exactly why I need someone to help me, because I need my son. Okay, so Monique, get in touch with us. We can help you. How long does it take for the I-751 to be approved? Why does it take so long? It's very backed up right now. And so you could be looking at around 2 years to get that, maybe even more. Some people, it has been more. And, I find sometimes when you're not submitting the evidence correctly, or you're trying to submit it by yourself without the spouse, it can create a longer process for you. So that's where it's important to get that representation. Can I call you today about the NVC case? So the way this works is you can schedule a consultation. You can definitely call today and schedule that consultation, or you can go to the website. The link is in the profile. It's going to take you to the contact page where you can just walk through that and then select a date that works for you and me, and then we can talk about it. Can having your younger citizen children give you good chances to get T or U visas if you have evidence as well? So there's an aspect of the T visa that requires you to show extreme hardship if you don't get the status. And that's where if you have US citizen children, you can't return to your country with your US citizen children. It can show, you can use that evidence to show that you'll experience extreme hardship. Is waiting over a year for a spousal interview date in Jamaica normal? Yep, Rosanna, unfortunately, it is. It's very backed up right now. Boss Baby Dunny, you're welcome. Can I apply for a work permit, work sponsorship, and what is the process to do so? What is the procedure? You're gonna have to. It's that will take me a whole other hour. You'd have to have an employer most of the time, or if you can show exceptional ability or extraordinary ability, there may be ways there as well, but that's a whole other live. So please, I'm now in New York City. I submit an I-130, my document 4 months ago. How long are they going to prove to me? So usually when you submit it, you should have gotten a receipt notice to acknowledge that it's in process. And right now, it depends on the relationship that you're applying based on, but I'm seeing over a year to get decisions on the I-130, on the I-130 by itself. When you're applying for adjustment of status, so my case is about 6 to 8 months, but keep in mind that that does not mean that I'm guaranteeing results in the future. Hello, I'm a 29-year-old. My father lives overseas and he wants to file for me, but our last name is spelled incorrectly. He did a deploy but it is not. So I think deploy, I don't know if that means correction, but it's not affecting me to change my last name. So, when we're talking, yes, that can present challenges when he's applying for you, if he's applying for you, and if he's not on your birth certificate. So, all of that can play into the requirement for you to get a DNA test. Do you do mandamus lawsuits? If so, how much is your fee? So I don't personally do lawsuits, but if my clients get to the point where we need to do one, then we do have attorneys that we contact to file those. I submitted an I-130 for my brother, which is still pending. If I want him to come to my wedding in the US, do you think that he will be granted a non-immigrant visa? It's going to come down to him with the evidence he has to show that he has strong ties to his country and that he will return. And that really is on a case-by-case basis. So do you take asylum cases? Absolutely. Schedule a consultation and let's talk about your situation and confirm you qualify. What does it mean security check is pending? So it's chances are if I don't know in what context you're talking, but if they are doing a security check during your process, your adjustment of status, it's related to the background check. All right. So that's going to be it for me today. I don't have anything else, and I'm going to sign out, but I will be back tomorrow. I aim to be on here at 4:30 p.m. Eastern Time. On YouTube, I'm usually here around 4 p.m., but I wanted to make sure I jumped on YouTube today because I was a little late. So thanks for your patience. Thanks for, being patient as I went through the technical difficulties earlier. You're welcome. Thank you for the love. I'll be back tomorrow where we'll talk more about a topic and then you can bring your questions as well. Have a great evening. And remember, go to the link in the profile to schedule that consultation. All right. Bye-bye.